4, 3, 2, 1. Good afternoon and welcome to the South Carolina Public Service Commission. We are here today for our weekly business meeting. It is December 18, 2025, approximately 1 p.m. All commissioners are here in the commission room and we are ready to proceed, Mr. Scarborough.
Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the date of the next business meeting. Staff recommends that the next regularly scheduled commission business meeting be set for Thursday, January the 8th, 2026 at 1 o'clock p.m.
The next regularly scheduled business meeting will be January 8th at 1 o'clock, 2026.
Thank you, sir. Today we have 7 items on the utilities agenda and 5 items on the transportation agenda. Item number 1 is in docket number 2025-289E, and all commissioners are eligible to vote. This is a motion from Duke Energy Carolinas, LLC, to dismiss the complaint filed by Mr. Joseph Oberman.
As to item number 1 is read by Mr. Scarborough, do I hear a motion?
Mr. Chair.
Mr. Vice Chair.
Mr. Chair, fellow commissioners, I move that the commission grant Duke Energy Carolinas, LLC's motion to dismiss on the grounds that it fails to allege any violation of an applicable statute or regulation with respects to the complainant's account or service. The motion to dismiss is also granted on the grounds that the complainant has not articulated a claim upon which the commission can grant relief. The clerk's office is directed to cancel the hearing currently scheduled for February 24th, 2026. So moved.
Thank you, Mr. Vice Chair. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no, the ayes have it.
Item number 2 is in docket number 2025-316E, and all commissioners are eligible to vote. This item involves final disposition of this docket.
As to item number 2, is there a motion?
Mr. Chairman,
Commissioner Britt.
I move that the commission grant the petition for a declaratory order for Pinopolis Reliability Project LLC, declaring that the proposed Pinopolis 300 MW nameplate lithium iron phosphate standalone battery energy storage system is not a major utility facility as defined by South Carolina Code annotated section 58-33-22A and does not require a certificate of environmental compatibility and public convenience and necessity. The commission grants this request based on the characteristics of this proposed project as described in the petition. So moved.
Thank you, Commissioner Britt.
And Mr. Chairman,
Yes, sir. Continue if
could-
you please.
say one quick thing, and I'll try to be as brief as I can. Recently, Commissioner Justin Williams asked me a question about Spartanburg County. I wanted to know what was the real reason for our success in economic development and growth. And I thought it was a great question. And I told him after thinking about it a little bit, I said, we hired a young lady from right here in Columbia, Lexington County. Catherine O'Neill was our county administrator. And what she did, she came in and really removed all the roadblocks to our processes that we had had in place for a number of years, and also put in some processes for permitting to make it streamless, to really focus on the customer. And I really give her credit for doing that. And as I told Commissioner Williams, that started us on the road and the trajectory of the success that we've had over the last 15 years. And I look at the South Carolina Energy Security Act that was passed back, I think, May 12th, which is now known as Act 41. It also streamlines the processes, for South Carolina, and particularly for the Public Service Commission. And they removed a lot of roadblocks and gave us tools, or they've given us tools to really expedite our processes, and have encouraged us to do so. And so I thank the General Assembly for doing that, because not only will it help us in our processes and removing the delays from the customers and that we're serving ultimately, as well as the partners that we have all across this state. And I think we'll send a message not only to the other parts of South Carolina, but Southeast and the nation as well, that our General Assembly passed a tool that gives us the ability to help transform South Carolina, and it makes us a partner in the process and not a roadblock. So with that said, I'll move.
Thank you, Commissioner Britt.
Mr. Chair.
Mr. Vice Chair.
Mr. Chair, I would like to just make a few comments regarding Commissioner Britt's motion. Commissioner Britt, I support your motion. I'm proud that the commission was able to receive this petition on November 6th, create a procedural schedule and deadlines that included written legal briefs and proposed orders, deliberate this matter, and be prepared to make a decision today. In my view, we met the standard for expedited relief as requested by the petitioner and prompt and expeditious review of such applications as required by Act 41. As your motion indicates, it is beyond clear that this battery energy storage system is not a major utility facility per the Siting Act, as it is not an electricity generating facility and therefore does not need to file an application before the commission for a certificate of environmental compatibility and public convenience and necessity. I would like to commend commission staff for efficiently and effectively preparing our briefing materials to meet our deadline. I would also like to give a special thank you to Executive Director Boyd and Technical Director Scarborough for developing a partnership with the Department of Energy, which gives us access to world-class talent through the Department of Energy Fellowship Program. I would also like to say that I found the footnotes in the petition to be helpful in understanding the technical issues presented to the commission in this matter. Commissioner Britt, fellow commissioners, I believe our ability to make decisions in an expeditious manner makes us an agency of choice. My hope is that all parties who appear before us have a regulatory experience that leaves them with no complaints about our responsiveness, our timeliness, our procedures, decisions, or orders. We have worked hard for at least the past 5 years to improve our responsiveness and timeliness of our decisions and orders, as demonstrated in docket number 2020-247-A. In fact, there was a time where it was thought that our commission could not issue orders in less than 90 days after a commission decision. But I'm proud to say that now our average order issuance is about 20 days from our decision to order. That's not happenstance, but a commitment to meeting the standards and expectations of our review committee. I must say that it's not been easy. We've had to confront some issues and make some adjustments along the way, but we have made significant progress. While we're not perfect and have more opportunity for growth and development, I firmly believe that we are committed to being a leader, an agency of choice in South Carolina's regulatory landscape, and not a hindrance or obstacle. Finally, I want to read a portion of Act 41, which in my view instructs the commission to do just what your motion does, Commissioner Britt, and that's make decisions in an expeditious manner. Specifically, I want to read South Carolina Code annotated section 58-37-110, paragraphs A and B. Paragraph A reads as follows, Given the importance of sufficient, reliable, safe, and economical energy to the health, safety, and well-being of the citizens of South Carolina and to the state's economic development and prosperity, the General Assembly finds that prompt siting, permitting, and completion of energy infrastructure projects, energy corridor projects, and brownfield electrical generation projects are crucial to the welfare of the state. Paragraph B reads as follows. All agencies are instructed to give expedited review of applications for energy infrastructure projects to provide reasonable and constructive assistance to applicants to allow the applicants to comply with any law and regulatory requirements as expeditiously as possible and to be guided by the policy goals established in subsection A. Commissioner Britt, I think our decision today meets that standard, and fellow commissioners, I think our decision today meets that standard, and for all the reasons stated, Commissioner Britt, I fully support your motion.
Thank you, Mr. Vice Chair. Any further discussion?
Chair Powers.
Commissioner Caston.
First of all, I agree that we should be expeditious in our decisions. No two ways about it. And having worked in Spartanburg County, as Commissioner Britt mentioned, and I agree with him, it's a very good place to work. I had to deal very often, I totally had to deal with federal, state regulatory agencies, and sometimes it was just aggravating. And that said, on this, while I absolutely agree with us doing our jobs diligently and expeditiously, I guess it gets down to what expeditious is, what that means to some. And I too appreciate what staff has done and the information they've provided. My concern is that I believe it's our role to not only be expeditious, but very judicial in our decisions. Do we have the appropriate information to make good and wise decisions? In this case, first of all, the project, I think, is due, they want it constructed by the end of 2027, which is 2 years away. I don't know how long this takes, and I certainly don't want to do anything to hold anyone up. It's not my desire at all. And I think I'm going to offer a substitute motion that I think would meet all those requirements. It'd be expeditious, and I think provide information that staff also had questions about, that I do also, that same staff. So I'll read that. I move that the commission request that Panopolis Reliability Project, LLC, and any other interested party provide, no later than close of business day on January 5th, 2026, with an extension available if needed, to the following questions and requests. An engineering and power flow diagram of the site that illustrates how all facilities listed in Exhibit A are interconnected. This should include location, length, and voltage of all interconnection lines and any associated interconnection facilities, as well as detailed lines that leave the site. Confirmation that the BESS will interconnect to the 115 kV switching station, and confirmation the BESS does not necessitate the construction of or direct interconnection to any transmission facility rated 125 kV or higher. The detail on the configuration of this BESS, including its interconnection voltage and presence of bidirectional power flow with the grid, is critical to decision-making regarding the status of this system. Therefore, we request additional detail to ensure our robust assessment of the proposed facility. And Chair Powers and fellow commissioners, how something is used and where it's used can matter relative to the Siting Act. And it is a storage facility. But to say that there's no due diligence needed, no additional information, I don't agree with that. I think we can do that in an expeditious way. And as the energy goes into the system doesn't know what it is. All that to say, I absolutely agree with the comments that have been made about doing this expeditiously and doing a good job. So that's my substitute motion, Chair Powers.
All right, thank you very much, Commissioner Casson.
Chair Powers,
Yes, sir, Commissioner Thomas.
I'd just like to make a comment. So basically, I'm concerned that Section 58-33-22B has not been addressed, and that's the part that relates to an electric transmission line and associated facilities. All of the attention has been placed on 58-33-22A, which is the electric generating plant and associated facilities. So basically, that's only half of what's supposed to be covered or addressed in the Siting Act. So my concern is that under the Code of Judicial Conduct, we're required to perform our duties with diligence. And I think that if we do not get the additional information, then we fail to meet the diligence obligations under the Code of Judicial Conduct. I'm 100% in favor of moving things forward as quickly as we can. And, but basically, in my opinion, the information that's been provided is not complete. We need more information. And so Commissioner Caston, for that reason, I will be supporting your substitute motion.
Thank you, Commissioner Thomas. Any further comments?
Chair Powers.
Commissioner Williams?
Thank you, Chair Powers. First of all, I have to say to Commissioner Britt and to Vice Chair Williams, multiple times in this position, I wish that I had been in the debate society in high school and college, because I so appreciate your oration and your delivery and what you said. But I find myself considering this as a novel question that hopefully is the first of a plethora of similar kinds of requests. My vote is going to be based on my interest that we, and I know we all share this interest, that we get it right, and that we have enough information to be confident in that, and don't have to reconsider it with later revelations. So I do believe that more information will help us. I think that we can do it swiftly, expeditiously, and I think that Commissioner Caston's substitute motion puts a timeline on that for us to do it. One of the reasons I'm confident we can do this is that the applicants have a separate docket where they have, that is not pertinent to our consideration here, but they have an application that is filed based upon the Citing Act requirements, and so the information is there, and that's part of why I'm confident that timing-wise we can get back to this question with due diligence, but with thorough diligence. And like my colleagues have said, I mean, I comment this as an independent thinker looking for truth and to meet the law. And I just don't have enough to know that this meets the law that we've been given. So thank you, Commissioner Caston, and thank you to all my colleagues. We're all struggling with this, or maybe not struggling, but we're all thinking diligently about it, and I appreciate that.
Thank you, Commissioner Williams. The only thing I would point out is that no decision we make will be precedential with future cases that may come in. And it's a new law, and we do want to get it right, and it's taking some work. Is there any further discussion? Hearing none, we'll proceed to a roll call vote on the substitute motion, beginning with Commissioner Caston.
Aye.
Commissioner Britt.
No.
Commissioner Thomas.
Aye.
Commissioner Vice Chair Williams.
I respectfully vote no.
Commissioner Williams.
Aye.
Commissioner Belser.
No.
And I vote no, the motion fails. Which brings us back to the original motion. Is there any further discussion on the original motion? Hearing none, we will go to a roll call vote, beginning with Commissioner Britt.
Aye.
Commissioner Thomas.
Respectfully, no.
Vice Chair Williams.
Aye.
Commissioner Williams.
Aye.
Commissioner Belser.
Aye.
Commissioner Caston.
No.
And I vote aye, the motion carries.
Item number 3 appears in docket number 2025-310E, and all commissioners are eligible to vote. This is a request from Dominion Energy South Carolina Incorporated for a like facility determination to rebuild a portion of the existing Fairfax-Yemassee 115 kV line as a single pole double circuit, and to move the Kennedy's Yemassee 230 kV line to the rebuilt section.
That's item number 3. Is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. On November 3rd, 2025, Dominion Energy South Carolina filed a request with the Commission for a like facility determination with regard to rebuilding a portion of the existing Fairfax-Yemassee 115 kV line as a single pole double circuit and then moving the Kennedy's Yemassee 230 kV line to the rebuilt section. Currently, the Kennedy's Yemassee 230 kV line and Yemassee 230 kV line share common structures for 1.3 miles. A common structure contingency loss of these lines causes violations of the North American Electric Reliability Corporation TPL-001 criteria. The TPL-001 standard exempts common structure contingencies if the distance is less than 1 mile. This project will move a portion of the Kennedy's Yemassee 230 kV line to structures that will be shared with the existing Fairfax Yemassee 115 kV line, thus resolving the contingency issues by reducing the distance that the 230 kV lines share common structures to less than 1 mile, pursuant to the compliance requirements of TPL-001. Dominion Energy South Carolina asked the Commission to decide that the project constitutes the replacement of an existing facility with a like facility and does not constitute construction of a major utility facility, for which certification would be required under the Utility Facility Siting Act and Environmental Protection Act, or the Siting Act. The company considered 3 options and found this solution to resolve the TPL-001 issue is the least expensive option evaluated and requires the least time to complete. The Siting Act provides that no person shall commence to construct a major utility facility without first having obtained a certificate. However, the replacement of an existing facility with a like facility as determined by the Commission shall not constitute construction of a major utility facility. South Carolina Code Annotated Section 58-33-110-1. The Siting Act further provides a like facility with reference to transmission facilities and without limitation includes any facility that represents the rebuilding, reconductoring, paralleling, increasing voltage, adding circuits, or otherwise reconfiguring of an existing transmission line or other transmission facilities, including, without limitation, projects to increase the capacity of such facilities, provided such facilities are A, located materially within the utility right-of-way or corridor, or B, substantially located on the property of a customer, prospective customer, or the state. South Carolina Code Annotated Section 58-33-20, subsection 10. I move that the Commission approve the like facility request of Dominion Energy South Carolina and find and conclude that moving a portion of the Kennedy's Yemassee 230 kV line to no longer share common structures for greater than 1 mile with the Yemassee 230 kV tie line by constructing a portion of the existing Fairfax Yemassee 115 kV line as a single pole double circuit with the Kennedy's Yemassee 230 kV as described in the application constitutes the replacement of an existing facility with a like facility and therefore does not constitute construction of a major utility facility for which a certificate would be required under the Siting Act. On December 10th, 2025, the Office of Regulatory Staff submitted its review letter to the Commission. While ORS did not object to the project, ORS did recommend that Dominion Energy South Carolina file updates with the Commission and ORS on the project's progress and notify the Commission and ORS when the project is completed. I move that the Commission further find and order that Dominion Energy South Carolina provide updates to the Commission and the Office of Regulatory Staff every 3 months up to the completion of this like facilities project, and that Dominion Energy South Carolina notify the Commission and ORS of the completion of this like facilities project within 10 days of its completion. I so move, and I have a very tiny comment.
Go ahead.
I just want to thank the company for the map that associated this application because it was essential in figuring out what this request was all about. Thank you.
Thank you, Commissioner Williams. Any further comment? Hearing none. All those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 4 is in docket number 2025-165E, and all commissioners, with the exception of Vice Chair Williams, who was on military leave at the time of the hearing, are eligible to vote. This item involves final disposition of this docket.
As to item number 4, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. This matter involves a complaint filed by a customer, Jessica Hayward, against Dominion Energy South Carolina. In a letter filed in this docket on December 16, 2025, Counsel for Dominion Energy South Carolina informed the Commission that the parties have entered into an agreement that covers the amount at issue in the complaint, among other issues. Given this agreement, I move that the Commission find and conclude that the matter is now moot, and as such, dismiss the matter without prejudice.
Thank you, Commissioner Williams. Having heard the motion, any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it, motion carries.
Item number 5 is in docket number 2025-216E, and all commissioners are eligible to vote. This item involves a proposed procedural schedule for this docket from Dominion Energy South Carolina Incorporated.
Item number 5, is there a motion?
Chair Powers.
Commissioner Thomas.
Thank you. By order number 2025-473, the Commission directed the Chief Clerk to open a docket to establish a competitive procurement program for each electrical utility concerning energy storage facilities to be located in South Carolina. The order also instructed the Chief Clerk to establish a procedural schedule. Docket number 2025-216E was created for Dominion Energy South Carolina. On December the 5th, 2025, Dominion Energy South Carolina filed a letter with a proposed procedural schedule as directed and pursuant to the status conference held on September the 11th, 2025. I move that the Commission approve the proposed procedural schedule as follows. Stage 1, application filed. The date is May the 8th, 2026. ORS intervenor third-party deadline to issue discovery on the DESC application is May 18th, 2026, with responses due no later than 10 calendar days after the date of issuance. ORS intervenor third-party comments, June the 12th, 2026. DESC deadline to issue discovery on ORS intervenor and third-party comments, June the 22nd, 2026, with responses due no later than 10 calendar days after the date of issuance. DESC reply comments due July the 13th, 2026. Further, I move that the Chief Clerk shall have the authority to adjust the procedural schedule as necessary for good cause shown by the parties. So moved.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it, the motion carries.
Item number 6 appears in docket number 2025-253E, and all commissioners are eligible to vote. This item involves a letter requesting an extension of the commission order deadline that TOS SC Solar One LLC and Sumter County agreed to in this docket.
Item number 6, is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. On December 5th, 2025, applicant TOS South Carolina, TOCE TOS, South Carolina Solar One LLC, advised the Commission that the applicant and intervening party, Sumter County, had agreed to extend the time in the review period for the Commission of the application filed by TOS, which is seeking a certificate of environmental compatibility and public convenience and necessity for an energy infrastructure project pursuant to Article 3, known as the Energy Infrastructure Projects in Chapter 37 of Title 58 of the South Carolina Code 5837-100 through 140. Applicant TOS proposes extending the Commission's deadline to issue an order to June 1st, 2026. Before making this proposal, TOS stated that the Office of Regulatory Staff was consulted and did not object. Section C of Section 5837-120 states, the applicant and agency may mutually agree in writing to extend the 6-month review period. Such agreement shall be in writing and state a specific date on when the extension will end. The agency shall not stop, stay, or otherwise alter the review period without such written agreement with the applicant. South Carolina Code annotated 58, section 5837-120C. That was the reference to that section. TOST makes this proposal to accommodate the extension of the formal evidentiary hearing to March 25th and March 26, 2026, as requested by TOST and discussed with parties. That's from TOST's letter dated December 10th, 2025. I move that the Commission find and conclude that the applicant, TOST South Carolina Solar One LLC, by and through its December 5th letter, demonstrates a willingness for an agreement between the applicant and Commission to extend the review period of its application to June 1st, 2026. I further move that the Commission accept and grant the extension. So moved.
Thank you, Commissioner Caston. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 7 is in dockets numbered 2022-93E and 2022-97E, and all commissioners, with the exception of Commissioner Britt, who had not occupied his current seat at the time of the hearing, are eligible to vote. This item involves a letter from S.R. Lambert 1 LLC and S.R. Lambert 2 LLC, requesting that the Commission correct its order number 2022-712.
Thank you, Mr. Scarborough. Having heard the item, number 7, is there a motion?
Mr. Chairman,
Commissioner Belcher.
thank you. On December 10th, 2025, counsel for S.R. Lambert 1 LLC and S.R. Lambert 2 LLC, who I will collectively refer to as Lambert 1 and 2, filed a letter requesting an amendment to Commission Order Number 2022-712, dated and issued on October 20th, 2022. The request seeks to amend or modify references to Lambert 1 and 2 as public utilities. These references in the order are found in the findings of fact, conclusions of law, and discussion of the law as applied to the facts of the case. In reviewing counsel's letter of December 10, 2025, in order number 2022-712, I agree with counsel that references to Lambert 1 and 2 as public utilities are not proper. Further, these references are not mere clerical errors or omissions. Therefore, pursuant to South Carolina Code Annotated Regulations 103-853B, I move the Commission adopt the following edits or amendments to Order Number 2022-712. Number 1, on page 6, under Section 3, Findings of Fact, Jurisdiction Number 1, A, delete the phrase "and pursuant to their applications are public utilities" within the meaning of South Carolina Code Annotated Section 58-33-26, and B, insert the phrase "pursuant to Sections 58-33-25 and 58-33-110(1) of the Siting Act. Lambert 1 and Lambert 2 must seek a CEC PCN from the Commission for commencing to construct the major utility facilities described in the application. The amended sentence would read, Lambert 1 and Lambert 2 are wholly owned subsidiaries of Silicon Ranch, duly authorized to do business in South Carolina and pursuant to sections 58-33-25, subsection 5, and 58-33-110, subsection 1 of the Siting Act. Lambert 1 and Lambert 2 must seek a CEC PCN from the Commission before commencing to construct the major utility facilities described in the application. The second edit is found on page 13 under Section 2, Applicable Law. Delete the sentence which reads, South Carolina Code Annotated Section 58-33-20, subsection 6, defines a public utility as any person engaged in the generating, distributing, sale, delivery, or furnishing of electricity for public use, and replace the sentence with South Carolina Code Annotated Section 58-33-20, subsection 5 defines person as including any individual, group, firm, partnership, corporation, cooperative, association, government subdivision, government agency, local government, municipality, any other organization, or any combination of any of the foregoing, and shall include the South Carolina Public Service Authority. The Third edit is found on page 14 under section 3, discussion and application of law to the facts. Delete the first sentence of the first paragraph, which reads, applicants are public utilities, and since they are seeking to construct and operate a major utility facility, they must obtain a certificate issued by the Commission as required by South Carolina Code Annotated Section 58-33-110, subsection 1, and replace the sentence with applicants are persons as defined in South Carolina Code Annotated Section 58-33-20, subsection 5, seeking to construct and operate a major utility facility, and therefore must obtain a certificate issued by the Commission as required by South Carolina Code Annotated Section 58-33-110, subsection 1. The next edit would be on page 49 under section Roman numeral V, conclusions of law 1. Delete the sentence reading Lambert 1 and Lambert 2 are public utilities within the meaning of South Carolina Code Annotated Section 58-33-20, subsection 6, and replace with the sentence Lambert 1 and Lambert 2 meet the definition of person as defined in South Carolina Code Annotated Section 58-33-20, subsection 5. The next edit is on page 49 under section 5, V for Roman numeral V, conclusions of law 2. Delete the introductory phrase as public utilities. The amended sentence will then read, Lambert 1 and Lambert 2 are required to seek authorization under South Carolina Code Annotated Section 58-33-110, subsection 1, to construct and operate two major utility facilities as defined by South Carolina Code Annotated Section 58-33-20, subsection 2A. I move that this directive be served on the parties of record to this docket. The amendments or modifications proposed in this motion are not simply correcting clerical errors or omissions. Therefore, in accordance with South Carolina Code Annotated Regs 103-853B, which provides in relevant part that if the rescission, modification, or amendment pertains to other than clerical errors or omissions, parties of record shall be provided notice and opportunity to be heard. This directive must be served on the parties of record to provide notice and for the opportunity to be heard. Any party wanting to be heard may submit written comments related to the amendments proposed herein by Monday, January 5th, 2026. Any party which may request a hearing on this matter must submit the request no later than Monday, January 5th, 2026. Written comments or hearing will be limited to the amendments and modifications described in this motion. Should a party request a hearing after notice contained in this directive, I move that the Commission direct the Chief Clerk to issue a notice of hearing to schedule a hearing. Should none of the parties request a hearing pursuant to South Carolina Code Annotated Code Annotated Regulations 103-853B or otherwise object, I move the Commission issue an amended order which includes the amendments and modifications described herein. Finally, South Carolina Code Annotated Regs 103-829A provides for response to motions to be filed within 10 days after service of the motion. I move pursuant to South Carolina Code Annotated Regs 103-803 that the Commission waive the portion of Regulation 103-829A which allows 10 days for any responses to motions. I move the Commission find that waiver of the 10-day period for response to the motion is appropriate in this instance because pursuant to South Carolina Code Annotated Regs 103-853B and as part of this motion or directive order if this motion passes, parties will be provided the opportunity to comment on both Council's request to amend, which I'm treating as a motion, and the proposed amendments set forth in this motion. Accordingly, and because no party will be denied an opportunity to be heard on Council's request to amend and on the proposed amendments set forth herein, I further move the Commission find that waiver of the 10-day period for responses contained in South Carolina Code Annotated Regulations 103-829A is not contrary to the public interest. I so move, and Mr. Chairman, I have comments.
Thank you, Commissioner Belcher. Go ahead.
Mr. Chairman, we received this letter seeking what Council has described as correction of errors in a prior Commission order. I know that some time has elapsed, but upon reading his letter, and reading the order and the references to the order that he pointed out, I have to agree with him. Therefore, I make this motion to kind of consolidate things, that we take the letter and pursuant to our authority under commission regulations to modify or amend an order, any notice and opportunity to be heard under that regulation, to consolidate them so that we can move this forward expeditiously, so that we can make a correction if the commission agrees that there's an error. I know there's been some discussion that perhaps this matter should have been a more formal motion. While that might be preferable, I think that we are knowledgeable enough about our statutes and our regulations to understand when somebody's pointing out something that might be incorrect. And I just think we need to move as quickly as we can to correct that if we agree that there's an error here. So that's my motion. Thank you.
Thank you, Commissioner
Chair.
Belzer. So, just one second, Mr. Vice Chair. So by waiving the 10 days, instead we're really giving them almost 3 weeks.
Well, we're waiving the 10 days for a response to the original letter is what I'm asking for. But parties have the opportunity pursuant to the regulation that speaks to amending, rescinding a commission order. They have to be given or granted an opportunity to be heard. And so that's what we're doing now, is we're notifying them of the filing, which they have already been served with, or should have been through the electronic filing system. But we're notifying them that we've reviewed the letter, we've reviewed the order, we agree that there needs to be some corrections. I have tried to make corrections which I feel like correct the order that in a manner, it's not exactly the same as proposed by counsel for Lambert, but I think that they meet they comply with the statute, and they're not. For instance, counsel for Lambert didn't ask to substitute and put in a motion in his redlined order. He did not request that Lambert 1 and Lambert 2 be found to be a person. Well, person is defined in the Citing Act, and they're definitely a person. And actually, the statute that talks about the need to get the certificate says no person may commence construction without, paraphrasing here, construct a major utility facility. I think we're all in agreement that Lambert 1 and 2 meet the definition of major utility facility. I don't think they meet the definition of public utility because they're not holding themselves out as serving the public at large, or I think as the definition says, I can't remember the phrasing, but they are building this facility to provide energy under contract to a public utility. So they are not, in my opinion, Lambert themselves are not a public utility, and that's what he's asking to be corrected, and that's what I'm trying to do and consolidate it into one process moving forward. Parties can comment. If they agree or disagree, they can comment on his letter and on the proposed fixes that I've set forth. They can do that in writing. They can request a hearing, and we can deal with that when those requests come in. But it's just,
Thank you very much. Mr. Vice Chair, sorry to interrupt.
No, that's fine, Mr. Chair. Thank you for recognizing me. I just wanted to commend Commissioner Belzer on her demonstration of accountability. I agree with her position. If we position on the law and position on the fix, if we make a mistake, it's brought to our attention, let's fix it and move on. So thank you for your motion, Commissioner Belzer. I'm proud to support it.
Thank you, Mr. Vice Chair. Is there any further discussion? Mr. Castle, Commissioner Williams, whichever one.
Commissioner Belzer and fellow colleagues, as a non-attorney, it's kind of interesting to read the law and interpret our processes, and ultimately what I've decided is that, Commissioner Belzer, your the process that you are offering gives all of the parties an opportunity to comment. And ultimately, if there is concern about the substitution of public utility with persons, I hope that we will hear it. I'm concerned that we don't understand the implications, but I recognize that the process that you're offering gives the opportunity for comment, and I beg that if there are alternative positions that they are presented through the docket.
Thank you, Commissioner Williams. Any further comment?
Chair Powers.
Commissioner Caston?
Again, I don't want to come across as someone that's trying to slow things down. I'm not. I am 100% about doing things as expeditiously as possible. I don't know the exact time frame, but you know, this is like 3 years, 57 days plus or minus old, and I understand that. But I do think there needs to be some additional internal discussion and thought. I don't necessarily disagree that they're not a public utility. Don't agree that they are. I don't know. I don't even know if that's completely what's being asked or how to ask it. All that said, I believe that internally, even amongst, say, a legal opinion, it's not uniform. I mean, it's not, 100% there. I have some concerns or questions relative to maybe the way this is being approached, but nonetheless, I'm not taking a position whether they are or not, but I do think if it's been that long, I'm not sure that a little bit more time to make sure we're, if possible, in one accord would not be better, because I'm not sure what the consequences of any of this is at this point in time. Anyway, that said, with the greatest respect, and I know how much effort you put in it, I'm not prepared to support this motion at this time.
Thank you, Commissioner Caston. Any further comments?
Mr. Chairman,
Commissioner Belson?
the edits and corrections to this order will, in my opinion, do not change the order granting them permission to site this facility where they are. It is merely removing the characterization of these entities as public utilities, which they're not, from the order. That's all it's doing, or that's all I intended to do.
Thank you, Commissioner Belcher. Any further comments? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Belcher.
Aye.
Commissioner Caston?
Respectfully, no.
Commissioner Britt? Oh, Commissioner Britt was not here at the time. I'm sorry. Commissioner Thomas?
Respectfully, no.
Vice Chair Williams?
Aye.
Commissioner Williams?
With respect for all of my colleagues, yes.
And I vote aye. The motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda. In Part A, there's only one application for a new Class C certificate, and all commissioners are eligible to vote. Item A1 is in docket number 2025-324T. This is the application of Links Transportation LLC for a Class C non-emergency certificate.
That's the item A1. Is there a motion?
Chair Powers.
Commissioner Caston?
Thank you. I move that the commission approve the application of Links Transportation LLC for a Class C non-emergency certificate. This Class C non-emergency certificate grants to Links Transportation LLC the authority to provide motor carrier services as follows. Between points and places in the state of South Carolina, restricted to 7 passengers, including driver. I move that the Commission find that Links Transportation LLC is fit, willing, and able to provide the service to the public as requested. I move the Commission find a certificate shall be issued by the Office of Regulatory Staff to Links Transportation LLC upon compliance with South Carolina Code annotated Section 58-23-10 as amended and the applicable regulations for motor carriers, South Carolina Code annotated regs, Volume 10, 2012 as amended, and the requirements listed in Exhibit A attached to this directive. So moved.
Thank you, Commissioner Caston. Haven't heard the motions. Any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it, and the motion carries.
In Part B of the transportation agenda, there are 2 requests to cancel certificates that the Commission may address together, and all commissioners are eligible to vote. Item B1 appears in docket number 2025-232T. This is a request from Y Drive LLC to cancel Class C Charter Certificate number 10064. Item B2 is in docket number 2025-113T, which is a request from Low Country Cab and Courier Service LLC to cancel Class C Taxi Certificate number 10034.
That's items B1 and B2. Is there a motion?
Mr. Chairman,
Commissioner Britt.
I move that the Commission grant the request for cancellation of Class C certificates in agenda item numbers B1 and B2 as identified by Mr. Scarborough. A directive order will be issued in each docket granting the motor carrier's request for cancellation.
Thank you, Commissioner Britt. Is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it.
In Part C of the transportation agenda, there is 1 request to amend a certificate, and all commissioners are eligible to vote. Item C1 is in docket number 2002-159T, which is a request from Mr. Charlie Russell to amend Class C Taxi Certificate number 7235 to read Travis G. Russell.
As to item C1, is there a motion?
Chair Powers,
Commissioner Thomas.
I move that the Commission grant the request of Charlie Russell to change its name and amend its Class C Taxi Certificate number 7235 to read Travis G. Russell.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it. Motion carries.
In Part D of the transportation agenda, there is 1 request to reinstate a certificate, and all commissioners are eligible to vote. Item D1 is in docket number 2023-53T, which is a request from Troy Johnson Intergenerational Daycare Incorporated for reinstatement of Class C non-emergency certificate number 9797.
Is there a motion as to D1?
Mr. Chair.
Mr. Vice Chair.
Mr. Chair, fellow commissioners, I move that subject to compliance with all applicable statutes and the Commission's rule and regulations, that the Commission reinstate the Class C non-emergency certificate number 9797 for Troy Johnson Intergenerational Daycare Incorporated. So moved.
Thank you, Mr. Vice Chair. Is there any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Those opposed by no. The ayes have it.
Mr. Chairman, this concludes all business noticed before the Commission today.
Thank you, Mr. Scarborough, and thank you all who have joined us.
Mr. Chair,
Yes, sir.
before we adjourn, I would like to take a point of personal privilege.
Certainly, I almost overlooked that.
I regret to inform everyone that former Commissioner O'Neal Hamilton, who represented District 7 from 2004 through 2020, has passed away. He was first elected to the Public Service Commission in March of 2004. During his tenure at the commission, he served as vice chairman. He was elected there July 1st, 2004. He then served a term as chairman from July 1st, the term started, on July 1st, 2006, and then served a second term as chairman, which started on July 1st, 2013. He also was active in the National Association of Regulatory Utility Commissioners, where he served as the chairman of the Committee on Gas, and he also was appointed to the NARUC Board of Commissioners. In honor of his legacy of service across the state and to the commission, I offer his obituary. The family of Commissioner O'Neal Hamilton of Bennettsville, South Carolina, is saddened to announce his passing on December 16th, 2025, at the age of 92. Commissioner Hamilton was born on January 27th, 1933, in Dillon, South Carolina. He was preceded by his wife, Consula, after a long, adventurous life. Commissioner Hamilton attended public schools in Dillon, where he excelled at sports. He also earned the rank of Eagle Scout with Scouting America to begin his life of leadership and service. After graduation, Commissioner Hamilton attended North Greenville College and played on the football team while obtaining an associate's degree in business administration. From there, he had a successful career in insurance in Cary, North Carolina, and Bennettsville, South Carolina. He retired as agency manager with South Carolina Farm Bureau in 2001. During his tenure at South Carolina Farm Bureau, he and Consula enjoyed many travels across the United States and Europe with colleagues who became even closer friends. After retirement, Commissioner Hamilton started a second career when elected by the South Carolina General Assembly as Commissioner for the South Carolina Public Service Commission, District 7. From 2004 to 2020, he held leadership positions as Vice Chairman and Chairman and served on the National Association of Regulatory Utility Commissioners for multiple terms. His commitment to community work was tireless. He served on city and county councils in Cary, North Carolina, and in Bennettsville and Marlboro County. He served on the South Carolina Highway Commission, PD Council on Governments, and the South Carolina National Association of Counties. He was a lifelong learner and garnered certificates and professional designations from the National Judicial College at the University of Nevada, as well as the annual Regulatory Studies program at Michigan State University. Commissioner Hamilton was a devoted father, grandfather, and great-grandfather. Nothing thrilled him more than spending time with his family and extended family and friends at home in Bennettsville or in Cherry Grove Beach. In the middle of a loud celebration, you could find him sitting with one of his grandchildren, or more recently, a great-grandchild, while he quietly dealt with their specific needs. His smile and brilliant blue eyes would be shining as he listened to whatever they had to say. He adored his children and grandchildren, affectionately bestowed each with a special nickname. Commissioner Hamilton and Consula hosted many family events, but none more special than the Covenant Street annual reunion on Christmas night. He would usually call the meeting to order with sharing of a special memory or by highlighting some member's achievement, add a special prayer, and a feast would be enjoyed by all. Commissioner Hamilton is survived by his son, Gordon and Beverly Hamilton, daughter, Kimberly and Billy Bundy, grandson, Neil and Jen Hamilton, granddaughter, Katie and Robert Hartman, grandson, Will and Megan Bundy, and great-grandchildren, States Hamilton, Charlie Hamilton, Maddie Hartman. The family of O'Neal would like to especially thank the staff and the loving, devoted team of caretakers at Laurel Crest Retirement Community. A funeral service will be held at 12 p.m. Saturday, December 20th, 2025 at First Methodist Church in Bennettsville, South Carolina. Mr. Chair, thank you for giving me the time to honor Commissioner Hamilton.
Thank you, Mr. Vice Chair, and I'm going to take privilege and follow that up. I have known O'Neal and Consula my entire life. Growing up, his son Gordon and I were contemporaries and have been good friends. We attended things together when we were couples. And he is having some health problems, so I would ask that people remember Gordon as well. When you think of O'Neal, I would say growing up, every young man in Bennettsville, Clio, Marlboro County, had a crush on Consula. She was a gorgeous lady and the sweetest person I believe I've ever known. And it really touches me to see this passing, and I hope everyone will remember that we're talking about some very, very special people. And please keep them in your thoughts over the next few days. Any other comments? Ms. Scarborough, again, thank you for today. Thank all who joined us. It is a wonderful chance, wonderful time of year that not just Santa Claus, but we can all do something for other people. And I hope you'll find somebody and surprise them real well. We are adjourned. Merry Christmas.